3 weeks since the trio responsible for the disappearance of Joshlin Smith started serving their life sentences. Mpilonhle Smith, Jacquen, Appollis, and Steveno van Rhyn appear unwilling to go down without a fight. Their lawyers have now filed applications for leave to appeal both the convictions and the sentencing. To help us unpack what this all means, especially the grounds for appeal and what could happen next, I'm joined now by legal analyst, Advocate Mpilonhle Baloyi. Good afternoon, Advocate, and thank you for your time. So it's not as simple as saying, I'm going to appeal and therefore, you are granted. You need to show and apply for leave to appeal. And I think I remember at the point of sentencing or at the conviction, in fact, at the sentencing, the question being posed, only one of the three had at that stage indicated that they intended to apply for leave to appeal. So what is entailed in applying for leave to appeal in a case such as this one?
Thank you, Tula Sizwe, and good afternoon to our viewers. It's very surprising to see that at this stage the accused have elected to appeal both the conviction and the sentence. And what's important to understand is that application for leave to appeal, it's not automatic. They have to apply, and the same court that granted the conviction and sentence needs to give leave to appeal, with the Superior Courts Act's guidance on appeals indicating that the main thing that they need to show emphatically, it's reasonable prospect of success and showing how the court of first instance was wrong in their decision and how a different court could come to a possible different decision.
And then how difficult does it make that particular process, convincing the court that there are reasonable prospects of success when you did not present a case at the point at which you were supposed to present your own case? So when the state closed its case, none of them presented a version, none of them called witnesses, none of them testified. Is that a factor that would come into the equation here?
It absolutely has to be part of the equation, mostly because you did not get your version across. So when you challenge a verdict and sentence, you have quite a big hurdle to cross when your version is not on record. And if really, so you also get to question the motive behind this appeal. 3 weeks into serving their life sentences, now there is all of a sudden this application for leave to appeal. And the chances of a judge, because what you in essence asking of is the judge must see themselves as wrong in the decision that they made. Mm-hmm. So the chances of that happening are very slim. And if that leave to appeal is not granted, then they can petition the Supreme Court of Appeal. But the prospect of actually the same judge conceding to the fact that they were wrong in their own judgment is highly unlikely, and considering the fact that they did not testify in their own defense also works against them.
And that particular aspect of not testifying in your own defense or even calling other witnesses, does it talk to one of the elements if you are appealing the conviction? Because a conviction is a result of the weighing up of the facts as argued by the state, the facts as argued by the defense, as well as the law, applying the law. So if we don't have the facts of the defense, talk me through that element. How does that feature in appealing at least the conviction part of things?
You are absolutely correct, Tula Sizwe. And the challenge here is that the evidence which was adduced by the state was not rebutted. And if you're accused and you don't use the opportunity you granted to say, this is not correct, this is the correct version, and you give your version across, in the weighing of the evidence, your silence may lead to an adverse finding against you when you had an opportunity to defend yourself, lead evidence and testify in your own defense, and you simply declined to do so. And when we look at this case in its totality, and the thoroughness. When we look at the judge is quite senior, quite seasoned in the field. The comprehensive nature of the proceedings and the way the public was very involved in this matter, and the thoroughness of the state, I would still say they've got quite a hurdle to jump.
And lastly, Advocate Baloyi, on the issue of appealing on the sentence aspect of things, what's involved there? What are the principles?
You know, the irony behind that, sometimes somebody is not happy with a judgment, the conviction, and the sentence. The implications there is that the Court of Appeal actually has the jurisdiction to even impose a higher sentence. But I guess they've got nothing much to lose in this instance because they have already been granted a life sentence.
Yeah.
So, but those would be the ironical implications of taking a matter such as this on appeal.
Yeah, all right. I've got to thank you for your time this afternoon. It is great having this conversation with you.